This is a presentation from the 2013 Cannabis World Summit. Please visit www.cannabisworldsummit.com for more great cannabis information, which is available to you completely for free. This information is being made available to you in part thanks to our sponsors. Please visit their websites to learn more about their excellent products and services. The following presentation is for informational purposes only. The opinions expressed are those of the participants and do not necessarily reflect those of Leaves of Hope Productions, Inc. Please note that regardless of any statements expressed or implied in the following presentation, that we do not condone you breaking any laws. We are not providing any legal, medical, or financial advice of any kind. No comments about cannabis being a cure for any medical use, expressed or implied, is to be taken as a claim or guarantee. None of the statements have been verified by the FDA of the United States, Health Canada, or the governing organizations of your particular country. And again, this information is being provided for informational purposes only, and the participants exercise their freedom of speech discussing what they believe to be true. We do not guarantee the accuracy of any information provided. It is your responsibility to evaluate the information before you choose to make any use of it. Please consult with a doctor knowledgeable about cannabis prior to using cannabis, and or prior to discontinuing any medications you may be currently using. Please check with the laws of your country and region to determine whether you are legally permitted to use and or grow cannabis prior to any involvement with cannabis yourself. Even though we believe that cannabis ought to be legalized, we do not condone you violating any laws. Please review the legal disclaimers on the Cannabis World Summit website and only proceed to enjoy this presentation if you agree with all legal disclaimers, agree to hold the company, Leaves of Hope Productions, Inc., and the presenters harmless and are of legal age in your region. Thanks to Kevin MacLeod and Incompetech.com for the music used in this introduction.
So I've got Ryan from the Northern Ontario Compassion Club on the line today to talk to us about something really interesting. Initially, I contacted Ryan because we were thinking about discussing something about seeds that would be fascinating for many of you to learn about. However, the legal and political environments, particularly here in Canada, and so I realized from Ryan's speaking so knowledgeably and eloquently, and he really knows his stuff about everything that's going on. I asked him if instead of talking about the seeds, if he can actually talk about the current legal and political situations here in Canada. So this call is primarily of importance for those of you who are Canadian. If you're Canadian, definitely please stay tuned and listen in on this. Those of you who are not Canadian, you might find this interesting because, of course, with all countries, we're all dealing with legal situations, so you might find some interesting tidbits that you can also consider for your own countries and your own legal environments. But I'd like to thank you, Ryan, for taking this call and for sharing with us some of this wisdom. And this was actually an unexpected pleasure from everything that I've learned from you, speaking with you a little bit before. So thank you, Ryan, from Northern Ontario Compassion Club.
Yeah, no problem.
So Ryan, actually, this of course, you've shared so much information for me, and as I explained to you before, unlike other callers, other speakers, and other people that I've interviewed, I've of course have been very prepared for the calls, and I am fairly knowledgeable about the subjects. However, this subject I am of course Canadian, so I have some understanding of, but this is one that you're going to have to sort of carry the conversation more for the both of us here, for the benefit of all the listeners here, because I'm not really as knowledgeable about the Canadian laws and politics as you are, but this is absolutely fascinating. So please take the opportunity to enlighten all of us what we should know, and what I'm hoping that you'll provide. It's not only just fascinating information about what's going on politically here in Canada, but hopefully you can also provide some tidbits to all of us here in Canada, what to potentially do from a pragmatic perspective if we get arrested or other legal situations. So I'm not sure where we should even begin here, but you obviously know so much about it. Why don't you sort of pick the first topic here?
So I was thinking that what would be most important for Canadians to do if they own a computer, go to the CanLE website that I told you about. That's a free information site for Canadians to access legal information. So that's www.canle.ca. CANLII.org. And there they could find what's called the Controlled Drugs and Substances Act.
Mm-hmm.
They also
and there's a number of revisions of it, so of course, so when you click on it, make sure you find the most recent one, and the one that we're looking at is the since November 6, 2012 for this call.
Yeah, that's the one we were looking at this call. I happen to own a criminal code book that gives me all the writing in print, right? Mm-hmm. So in print, that's a key thing, is that when it's in print, it's considered a libelous document or a legal document, and it should be written correctly as to all the laws in Canada. And the person who has the duty in the country of Canada to write that book is the Attorney General for Canada. Mm-hmm. And so in 2003, on that CanLII website, we could look up R versus Hitzig 2003. Mm-hmm. OCA, that's the Ontario Court of Appeal. Okay. So we might have to scroll down in the listings underneath, because many cases have used the Hitzig case in their defense. Yes. But you'll find the actual R versus Hitzig 2003 by scrolling down in the CanLII database. Once you find it, it's very important for all Canadians to read that document from the front to the back.
Okay, I think I found it here. I'm just bringing this up so that I can, of course, look at what you're talking about and discuss this with you.
Yes, it's a very extensive document, and it focuses on a number of Canadians that required medical marijuana and weren't being provided adequate necessities in regards to their illness, and we're challenging the constitutionality of the law. Okay. In this case, the court recognized the law to be of no force and effect, as in Parker, R versus Parker, Parker. Okay. And Hitzig is Hitzig. So R versus Hitzig, R versus Parker. So Parker was the first big ruling where the courts ruled that the government had 1 year to fix the law, to make the law constitutional for all Canadians. And if they failed, the law in itself was of no force and effect. In 2003, at the Hitzig case, they ruled that the law was indeed of no force and effect, and they removed 20,000 charges from the logs in Ontario in regards to possession of cannabis. Okay. At the same time, the court re-established the law, which is contrary to the Interpretation Act, which I talked to you about a little earlier. And the Interpretation Act, can you explain what that is for the listeners here? It's an act. An act is a legal documentation that is binding in the way that people. It's kind of like a law. A statute or an act is a law that's not necessarily in the Criminal Code of Canada. Okay. So the Interpretation Act is how legal officials must interpret the law. Okay. And it's pretty specific. In Section 43, it states that that Parliament only legislates and courts only abrogate, meaning that courts can strike down the law, but they can't reenact the law. Parliament is the only one who reenacts laws. Okay. Anyways, that didn't happen in Hitzig. They reestablished the law as constitutionally viable and made it a law in Canada that if someone, and in Hitzig at paragraph 170, it states that once a person establishes medical need, they're simply exempted from it. So that goes back. So the implications of that, so technically regarding MMAR, so that
that supersedes it technically.
Yeah, technically, once you've established medical need, according to the judges the 3 court judges at the Ontario Court of Appeal back in 2003, once you've established your medical need, you're simply exempted from it. And so that brings me back to that Controlled Drugs and Substances Act that we were talking about earlier in Section 4. And Section 4 states that...
Hold on a second. Before you go on to Section 4 here, I'm actually at paragraph 170. I think I found the line. It's a long paragraph here, so I won't read the whole thing. But perhaps I'll just read what is relevant based on what you said. So although Parliament may subsequently choose to change it, that prohibition is now no longer invalid, but it is a full force and effect. Those who establish medical need are simply exempt from it.
Yeah.
The consequence removes the cloud of uncertainty from the marijuana prohibition in S.4 of the CDSA, a cloud which we are told in argument has created a very considerable confusion in courts and law enforcement agencies alike. A suspension of remedy would simply have continued that undesirable uncertainty for a further period of time. So the key part there is, of course, those who establish medical need are simply exempted from it. A direct quote from 170 of the Herzig... I don't know the exact legal terminology.
R versus Hitzig 2003 document.
Okay. So now you were about to mention something about the paragraph 4?
Yeah, paragraph 4 of the Controlled Drugs and Substances Act as of 2012, except as authorized under the regulations, no person shall possess a substance included in Schedule 1, 2, or 3. Well, it fails to say except as authorized under the regulations, or if with an established medical need, no person shall possess.
Which was in Herzig.
And because it fails to say that people are exempt when it was clearly the fact in Hitzig back in 2003, that is called an inconsistency in the law. Okay, so I'm going to just keep your mind on inconsistency in the law in Section 4. Now we're going to go in Hitzig. I don't have the paragraph exactly off the top of my head, but Hitzig was about not being able to get your friend to grow your pot for you if you're in a wheelchair. And they established the right of Canadians to be designated growers at that time. And so they gave the right for Health Canada to establish a system for designated growers to grow for people who are sick.
Okay.
In future court cases, such as Stephanopoulos or R versus Barron, in R versus Barron happened in the British Columbia Supreme Court, and R versus Stephanopoulos happened in the Ontario Court of Appeal. They also established that the designated grower program that they put in place in 2003 was insufficient and unconstitutional, and they allowed growers to grow for more than one person.
Okay.
They gave them the right, a slap in the face to the court that went through all the effort to deem the law unconstitutional. So the government slapped the court in the face with providing an answer to the fact that it could be more than one person.
Okay.
The argument, again, like I say, people argue it the wrong way, and the court takes pure advantage of it. So when they want to structure their questions, they need to be careful in how they structure their questions. Okay?
Yes.
And so the question would be that you should be allowed to grow for an unlimited amount of people, or that not more than one. So the question in the case was, I should be allowed to grow for more than one person? So they said, yes, you're right, you can grow for two.
Well,
whereas if you would have said, I should be able to grow for an unlimited amount of people with my knowledge, as much people as I have the resources to be able to grow for.
Mm-hmm.
Not more than one. And that's where the court utilizes that and changes that. So anyways, let's get away from that, and I'm going to go back into, now we can go to the Controlled Drugs and Substances Act in Section 5.
Okay, I'm going back there now.
Here we have, so we know we've established that there's designated growers in Canada. They're allowed to grow for other people. They're allowed to provide it for other people. But let's
hold on a second. Section, are we talking about Part 5 or Paragraph 5? Under punishment?
Part 1, Offenses and Punishment, Section 5 of the Controlled Drugs and Substances Act. trafficking in substance. Possession for the purpose of trafficking, punishment in respect of specified substance, and interpretation. 5.1. No person shall traffic in a substance included in Schedule 1, 2, or 3, or 4, or in any substance represented or held out by that person to be such a substance.
Okay.
That doesn't leave room for any exemptions. There are no exemptions in trafficking in substance under the current regime that has.
This is the most current. This is the most current document of the Controlled Drugs and Substances Act in Canada. This is the current one that we're looking at, and so obviously there is no exceptions built into that line, as you're pointing out here.
That's right. So no one is allowed, according to the police, that follow. In Canada, the policing agencies follow the Criminal Code of Canada and the Controlled Drugs and Substances Act as their mandate to uphold the law. That's their guidebook of what they must follow to uphold the law.
Okay. So we have incongruence in the laws, as you've pointed out, and of course the police are following these laws, but there's incongruences in them, and so of course they're sort of picking the versions of the law. I suppose that could be interpretations of the law that are most
it's not really interpretations. It says right here in the criminal code that no person shall traffic in a substance. And so when we have this inconsistency in law, we refer back to the Constitution of Canada Act, Section 52. And on that Canley website, you could pull up the Constitution of Canada Act and you could look at Section 52 for yourself. But when there's any inconsistencies in the law of itself, to the extent of the inconsistency, is of no force and effect.
Mm-hmm.
So there we have it. Section 4 and Section 5 are inconsistent with the laws of the country of Canada. Therefore, they have no force and effect. In Schedule 2 substances, which are under the Controlled Drugs and Substances Act, you can look into the schedules, and Schedule 2 is cannabis and cannabis derivatives.
Okay. By the way, just for what it's worth, because I'm a little bit confused also, I've been speaking to a number of people, and I remember there's been some laws. So there was a court case that recently got one, well, recently, a little while ago, that, you know, hash or cooking with cannabis or any kind of oil preparations, that was, of course, completely illegal. But, of course, I remember the court was one, and the court gave a year to stay that law for a year. What's the status on that, if I can just ask, because that's relevant to a lot of Canadians as well. Like, technically speaking, preparation of cannabis other than just dried bud, technically speaking, you're violating a really bad law. You know, any hash or even making brownies is technically, technically speaking, it would be better to actually.
Technically speaking, according to the criminal code as it stands, but the thing is like this: if the duty of the criminal code to be written is on the Attorney General for Canada, then the Attorney, by writing the book.
Conference
I think that once you go
started.
I'm not sure what's going on, why we're dropping these calls. It's unusual, but anyway.
Yeah, it could be the Attorney General for Canada over hearing my calls and just clicking the button.
They're cutting the wires on us, I guess. But you know, bottom line is obviously you and definitely myself as well. We're definitely sharing information, talking about doing stuff that they would definitely prefer us not to be doing. So anyhow, for what it's worth. Okay, so you kind of started talking about that hash reply based on that question that was asking about that court case. So can you just sort of pick it up from that point? Sorry that we got.
Okay. So we go back to the Charter of Rights and Freedoms, right?
Yes.
And Section 15 states that every individual is equal before and under the law and has the right to equal protection and equal benefit of the law without discrimination. And in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, mental or physical disability. Okay?
Mm-hmm.
So this is Canada-wide. And in the Hitzig decision, that's a 2003 Ontario Court of Appeal decision, they refer to that decision in the Barron decision at the BC Supreme Court. And they use the decision at the Ontario Court of Appeal as a standard for all of Canada. because of the equality under the law line in Section 15. Okay?
Okay.
So what that oil ruling and hash and cookies and that stuff that was from the British Columbia Supreme Court.
Okay.
And now because what happens in Ontario is good in British Columbia, what happens in British Columbia is also good in Ontario. And so people will try to lead you to believe that, oh no, that was a British Columbia ruling, not an Ontario ruling, and that doesn't apply to the rest of Canada. But indeed it applies to everyone in Canada. The cannabis laws in Canada are a federal act, federal law.
So if it's stricken down in one province, since it's a federal law, it's applicable everywhere.
That's right.
Okay.
And so don't right now, if there's a year of no force in effect on cookies and oils and hashes, then it's no force in effect across the board. That's not to say that the police agencies of those regions won't apply an old law or an old rule, but like I said before, Canadians have to understand that there are two courts, criminal court and civil court. Civil court is where we get compensated for or remedied for the actions the state has taken against our persons. Mm-hmm. So we need to look at civil law, we need to look at remedies, and we have to file civil litigations against the people that are betraying the laws of the country and betraying the people of the country, that are targeting sick and disabled individuals and ganging up on them like wolves on a sick deer.
Okay. So knowing this information now, so if someone gets attacked, let's just say gets arrested or gets some sort of police involvement or something along those lines, how can people use this information that we're discussing? Is there some way that they can somehow use this to their benefit to sort of get off the hook, or to say, hey, you guys are not within your rights to be arresting me? Like, do you understand the question I'm trying to attempt to?
I totally understand the question you're asking, and there's a couple different ways of going about this.
Okay.
Okay, and one of my biggest recommendations for everyone is to represent themselves, not to hire a lawyer, as the lawyer works for the state. The lawyers in Canada are members of the Law Society of Upper Canada.
Yes.
And they pledge allegiance to Her Majesty the Queen, just like the judge, just like the Crown Attorneys and everyone else.
Just to play Angel's Advocate, Angel's Advocate is sort of my term for Devil's Advocate here. That's not I'm just concerned about leaving people with the notion of not hiring a lawyer for the defense, because not everybody is savvy with how to defend themselves in court. So if they get to court, what would they do? So they're not being represented. How can they win their court case? Wouldn't they just be squashed very easily?
One of the ancient traditions in law, or a maxim of law, is called, those who can be fooled will be fooled. Okay? And I cannot be fooled, and they will not fool me. Okay? And so part of being fooled is having someone representing your person and not speaking up your innocence for yourself, not standing up and saying, no, I'm not guilty. I never did anything wrong. I operated under God's law. God's law is the supreme law of Canada.
Oh, yes. Can you explain that to our listeners about the Queen, how she violated that law and technically treason? That was fascinating how you explained that to me earlier.
Well, in 1953, the Queen was coronated. At her coronation ceremony, she swore an oath to the people of the Commonwealth. And you'd have to go to the Queen's coronation oath and read it for yourself. But it's along the lines of where she swore to uphold the laws of God to the best of her ability.
Okay.
And the laws of God forbid monarchies from giving royal assent to bills, acts, or statutes.
Okay. In
Canada and in all the Commonwealth countries around the world, the Queen, since her reign of 60 years, has given royal assent to over 3,400 bills, acts, or statutes.
So she's violated that God's law quite a few times.
In that sense, not to mention, and I mean, if we're going to look at God's law, and like I was saying earlier, our society has come a long way. We've our values have changed,
Mm-hmm.
and we've come together and created new laws that benefit the majority of people. And so, but in law, we still rely on the tenets of the legal system, the justification of why we're in the contract we're in.
Mm-hmm.
It says clearly that whereas Canada is founded upon the principles of the supremacy of God and the rule of law. That's the preamble to show the world that we're a theocratic nation.
Okay.
Okay? So that preamble and that notion and that oath that the Queen said to the people, well, a lot of people in Canada have been punished for breaking oaths, simple oaths, or have perjured themselves by lying under oath. And it's a pretty serious criminal offense to break an oath as just a simple slave in Canada.
Mm-hmm. Let alone a queen.
Let alone a queen. And there's in the Criminal Code of Canada, there's sections that talk about, and I don't have them right in front of me, but there are sections in regards to if a queen were to break their oath to the people.
Okay. Now, I remember you were kind of implying to me before when we were speaking about this before that essentially because the Queen violated this oath and is essentially a traitor against her people, that a lot of these other things that these mandates or whatever, I can't remember the exact word, are technically invalid. However, the reality of the situation is it seems that everybody's just ignoring the fact that she's violated that oath and that they're still upholding all these mandates, all these laws, and they're essentially acting as though she didn't violate any.
And to me, that would be fraud.
Okay.
When somebody fraudulently goes along with a plan that is in deceit to the people. Like, you can ask how many people in Canada understand that they're locked into a debt slavery where they're in a contract where they have to collect taxes and pay that taxes in the name of Her Majesty the Queen to the CRA, and why that's being done. That's being done because Canada filed a Section 11 Bankruptcy Act, labeled all their people as property of the state, and used their birth certificates to secure a loan against and to pay off a debt.
Mm-hmm.
And so all Canadians are together in a group paying off the debt of the loan, and therefore we pay that debt off through collecting personal income tax. However it is structured, it is awfully reminiscent of what it is to be a slave. And so it got me into looking and doing some research, and I came across the Citizenship Act. And in the Citizenship Act, in Section 24, it states that we have all pledged allegiance to Her Majesty the Queen. And in Section 32, it says that all citizens of Canada are hereby subjects of Her Majesty, are British subjects. And British subjects is a subject of the Queen, and a subject under definition is someone who's under dominion of another. Again, reminiscent of what
being a slave
it means to be a slave. You're a slave if you're under dominion of another. You're a slave or a subject. And a subject or a British subject is someone who's under slavery or tenure of the Queen, right?
Mm-hmm. So
we have a little discrepancy with international law that forbids servitude, slavery in any of its forms, in all of its forms.
Okay.
Okay. So then again, we have another breach of international law over someone that's trying to hold jurisdiction over people.
Well, I guess technically, could it be argued? I mean, I'm not a lawyer. I'm just speculating here. Could it be argued that just because technically it's different terms, it's no longer slavery, even though it may resemble slavery? Just many times things can be just shifted ever so slightly, so it's got a different connotation, and the net result it can be still the same. However, you can get out of certain legal situations just by shifting things around a little bit. Do you understand what I'm saying? Like, for example, like with patent law, you could just change the design a little bit, and now you got something that's not under the patent. You understand what I'm saying? Just using that as a metaphor.
I understand what you're saying, and realistically, today's society is far more advanced than we were 50 years ago or 70 years ago, and we understand a lot more now than we ever did before. And people are able to just pick up the computer and look up CanLII and get actual access to legal documents that might have been in a secure, hidden library only accessible by lawyers up until the mid-1990s and the explosion of the Internet.
Mm-hmm.
So it's now a time that Canadians should sit down, and whenever they're about to watch Big Brother, pick up the law book instead and read some law. Read how their law benefits them, and read how their law forces them into contracts and obligations that might not necessarily be properly done, And so that's so the one essence is challenge the jurisdiction of Her Majesty the Queen, and find your way out through God, because I pull out my Bible here. In the first page of the Bible that the court relies on, which is the King James Version 1611 Bible.
Okay. Are we talking in the Old Testament or New Testament?
Yeah, we're talking in the Old Testament part, the first page,
Genesis
of the Old Testament, in the creation of the earth.
Okay.
They talk about I think it's 29. Verse 29. I don't see my Bible. Just it's usually around here, right, somewhere.
Okay. Well, while you're looking for it, can you explain to people how is this relevant? Like, why are we going to a Bible at this point?
Okay. So if we fail to rely on the Queen as a jurisdiction over the people still rely on God's law as the ultimate law over man. Okay. As a theocratic nation of Canada. So it wouldn't necessarily take out the entire jurisdiction of law over man, because God's law would still prevail. The only thing is now, by going back to God's law, we have to omit the acts, statutes, and regulations and that have been made up until this point, right? And justified by the monarchy, although the monarchy did so in vain of their committed oath to the people.
Now, can I just go off on a tangent just really quickly here, because I'm sure some people might be left scratching their heads here, particularly those who are not Christian, God's law, and of course, some people will say, well, that's not necessarily my God or whatever along those lines. Now, just to be clear, the law of the country that was established years ago, that this is the basis of what God's law is.
All the Commonwealth countries that are under the monarchy government of Her Majesty the Queen, Regina, Queen Elizabeth.
Okay.
The second.
So we're not Bible thumping or something along this. We're just talking from a legal perspective here, because these laws are technically derived from this.
On the tenets of the legal system that governs mankind in Canada, you want to talk about, at first, we're thinking about, okay, well, how do they have control over us, and how can they punish us for using medicine? Okay? Even in their book of law, they contradict themselves, and they constantly abuse their power over the people that are obviously sick and disabled. So how do we find a remedy to the solution? Well, where does the real problem lie? The jurisdiction, obviously, the monarchy isn't telling the police not to do the brutal acts against the people. Who is can we plead to the Prime Minister or plead to the leader of the nation to free us from these not really. If the person at the top doesn't even follow the law herself, how can we rely on her to follow the law?
Mm-hmm. So now
kind of example to the people.
So now sorry, go ahead.
I find the people underneath her that are in the highest positions of authority realize that she doesn't need to follow the law, and people just go about their business. Do they have to follow the law? and then they don't follow the law, and then the Attorney General for Canada, who's the agent under the Queen, the top lawyer to write the criminal code, has failed to write that criminal code and correct the Controlled Drugs and Substances Act so that it would free sick Canadians from prosecution for cannabis possession or cultivation or trafficking, if they're trafficking to people who are sick and disabled. Okay?
Mm-hmm.
How do you defend against that? And I'm just offering you an idea that if you look to the law, and you look to the law like they look to the law, where they're saying they're protecting the people and using the law, then we're all going to use the law, right? So I'm just looking at the law, and I'm saying, well, guess what, guys? You know what? You broke your own law. And I want to hold you accountable for breaking your own law, just like you held these 450,000 Canadians accountable for possessing marijuana since 2003 to 2012.
So you're going to court now. Like, can you tell us about the court case? Because I think that ties in with what you've just said here. Like, so you're going to court. You're trying to fight this right now.
Absolutely. Part of the idea of court is people don't go to court unless they've been charged with an offense. Once they've been charged with an offense, they go to plead their innocence or they plead guilty at court. When you realize that there's something wrong with the law, many Canadians will just sit back and say, yeah, that's not right. That's wrong. That should be fixed. Somebody should do something about that. But nobody actually really takes the ball and goes and shoots the hoop. You know what I mean?
Okay.
I've taken the ball and I'm in a line drive for the hoop, and I'm going to the court for remedy, and I'm asking the questions, and I'm looking for a remedy. I've never been charged with the offense. I'm asking for a solution to the problem. The court is all about...
Like Myrna, he's basically reactive, whereas what you're just telling me right now, you're actually being proactive, where you're actually preemptive, where you're actually essentially putting the government on the defense now.
Absolutely.
So you're actually doing something that rarely ever happens. You're actually the offensive as opposed to the defensive, which is typically in the court case.
That's right. That's right.
So when is when are the court
cases? That's
what
more Canadians should be doing. More Canadians should be sitting down and looking at the wrongs that have been committed against them by this government and by the actions of these attorney general and court bodies or lawyers that have sent them up the river and allowed them to plead guilty to offense that didn't exist. Lawyers have a fiduciary duty to their clients, and if you look up the definition for fiduciary duty, it's a pretty extensive duty they have to their client's well-being. And if they allow their client to plead guilty to an offense that didn't exist, and the lawyer that you hired is supposed to know the law, right? They're supposed to be aware of the law, and that's why you hired them, because you're not aware of the law, and you need to hire a lawyer who's aware of the law. But then if the lawyer got them to plead guilty, got them to take a deal, got them to do anything that wasn't in their best interest because the law didn't exist, because it was in no force and effect, how can we rely on lawyers that don't know the law to represent us?
Okay, now you also said something of no force and effect. We, of course, discussed that previously. I don't think that we necessarily covered that in this call. But you were explaining to me before that essentially cannabis laws in Canada are under no force and effect because of Hertzig. I'm going to rely on you to explain this so that it makes sense for the listeners here. And perhaps I'm misunderstanding here, but technically speaking, people getting arrested for possession, particularly those who are claiming any kind of medical use, regardless of whether they have an MMAR, and that's actually another thing that we talked about before this call that I think we should also touch on as well. We actually read about it in the call that, of course, if someone displays a medical need, that essentially also what's the appropriate word here? Well, it precludes or it basically invalidates needing an MMAR or MMPR, because as long as you have a medical need and can demonstrate it, according to the Controlled Drugs and Substances Act, or wherever, or Hertzig, I think it was actually that said it. Hertzig, sorry. That's where. So essentially, we don't need an MMPR. All you need is just some sort of way to prove that you have a medical need.
Yeah, that you've established medical need. That's another big question. How do you establish medical need? Can you just go into the court with your doctor papers and say, Your Honor, my name is so-and-so, and I'd like to hereby establish my medical need, and here's my affidavit of my information, and I swear on it as it being true. And wouldn't you have then established your medical need? You've established the fact that you're sick and that you're in need.
Mm-hmm.
But they want to go further than that. What is established medical need?
And how serious is the condition has to be, too?
So that's a question. That's something that has to be raised in a court. And so before anyone gets charged with the offense, raise the issue, write it all up, and go in and say to the court, how do we establish medical need? And argue the points of, well, wouldn't this be a suitable way of establishing medical need? Or this be a suitable way of establishing medical need? Could you get a notary public that's able to sign legal affidavits under authority of the Queen and then again we go back to that authority of the Queen. Is it even a legal document? Or is it a document that's been done in fraud that you're agreeing to? And you're allowing to continue because you're okay with the fraud, because it doesn't affect you.
Mm-hmm.
I think it affects everybody as a whole, and I think common everyday income tax on people is wrong, and I think that's my personal opinion.
Well, I think that personal opinion, there's a lot of validity to it anyways, but I won't go into the whole income tax thing right now. But
Exactly.
Okay, so just try to wrap my own brain around this, and I'm sure people listening to this are probably also trying to wrap their brain around everything that we're discussing. So just to summarize everything that we've so far covered, just help me out with this, just so that we can nicely package this so that people can digest this mentally.
I put it like this. I put it like this. In Canada, we're all slaves.
Okay.
Okay. And we have to follow the Criminal Code of Canada.
Okay.
No matter if it's written wrong in fraud or right. And so we will get arrested. And most of us don't understand the law, so we pay a lawyer. The lawyer doesn't want to raise any issues with class of people, so they don't. They sell you out to a deal.
Mm-hmm.
And you go home with house arrest for 6 months or 12 months for an offense that doesn't exist under law, and for an offense that's been written in fraud in law, in the Criminal Code and the Controlled Drugs and Substances Act. And people are scratching their heads as how this can even be going on, and nobody really understands why it's happening. And it seems so unrealistic to most Canadians that the entirety of the program seems like a complete apparition almost. Like it's not real to people. They don't draw a reality to the program even existing, most Canadians.
Mm-hmm. Well, it's mind-boggling even just trying to digest and understand all this. So it's basically, it's illegal, but it's not illegal. There is no law, and yet there is laws. We can get busted, though we can't really be busted. You
can't be held accountable in a court if you raise the right issues. If you don't raise the right issues in court, your lawyer doesn't know the right issues to raise, then you're going to be found guilty.
Mm-hmm.
For an offense that doesn't really exist because it's inconsistent with itself, and therefore makes it of no force and effect under the Constitution Act of Canada. It's inherently wrong right from the get-go. The system is set up because there's $1 billion industry centered around arresting people, paying the extra officers to the task force to arrest marijuana people,
mm-hmm.
Paying for the cars that they need, the insurance that they need, the extra flak jackets, the extra guns. Now the lawyers are all getting paid. 450,000 people times $5,000 is a couple $100 million, and that's just the lawyer fees, let alone the money that the courts are making for processing all the people and all the people that work inside the courts, like the reporters, the stenographers. And if we take out that big chunk of Canadians from getting arrested, there's
a lot of people lose their jobs.
Oh yeah, there's a major hit to that legal system that was set up to have that as a viable industry. So marijuana being illegal is a viable industry that the court relies on for making a profit.
But you know what? Ironically, if I just can go on a little bit of a tangent here just for a moment, what's ironic is that really this legal and judicial industry doesn't really produce any value for society or for the world in any way, shape, or form. If we were to legalize it, of course, this whole industry would collapse. A lot of people would lose their jobs. However, more jobs would be created in the hemp growing industry, like farming and the industrial and agriculture and all these other benefits. These industries would grow. Lots of jobs would be created. But what is interesting is that here we are creating an actual value. We're creating actual products. So here we got an industry, the judicial one, that's really taking up taxes, taking up Canadian tax dollars, or anywhere in the world. I mean, the same applies actually. Creating no value, whereas we can actually collapse that industry, create a new industry that creates value. Rather than robbing taxpayers needlessly and destroying people's lives, we can actually be doing something that's productive as opposed to destructive.
That's right. And so what you're talking about is a realist system versus a liberal system, right? And so back in the 1700s, we had great thinkers like Immanuel Kant or Jeremy Bentham with the ideas of perpetual peace and harmony. And these are central ideas to the legalization of marijuana, right? Mm-hmm. People see the peace, they see the business, they see the money generated from it. Then you have the realist perspective where they're constantly set on war. They're set on profits of a few very rich people, mm-hmm. like how we had the big movement in New York last year with the 1%ers, the 99% taking Occupy, where the 99% of the people own 1% of all the money. Mm-hmm.
Or vice versa.
This is a structure. This structure has been developed since the time of the Romans, and the elite that control the world own not only the money but the structure. They created the structure of government so that they could split the parties and create parties that were basically selected individuals who are members of the parties. They're looked at as somehow a democratic peace process, but there is no democracy. Mm-hmm. The people that get elected by the voters go back to their group where they were initially chosen as by the elite to be representatives of that group in that region. But when they go back to the mass, they don't make decisions based on the voters that voted them in. They make decisions based on their party's ambitions.
Okay.
And the parties, who's funding the parties? We know that multinational corporations are funding these parties, all the countries around the world. Mm-hmm. In Canada, in 2001, we stopped.
Hello, you still there? Oh man.
I swear it's your phone, man.
Conference recording started.
Yeah, I swear it's your phone. It can't be my phone. My phone's never done this like this.
I've never had this problem either. But anyways, I'll take the.
Got a Colorado number, and the FBI is listening to our call. They're going, "Fucking cut this fucking guy off."
I don't know what's going on here, but this is unusual. I've never had call drops like this, but anyways, whatever. It is what it is.
I believe it was 2001 or it was 1999, and John Chrétien established the way that corporations could lend money to Canadians. They tried to become more transparent, and they stopped donations being able to be made to political parties by corporations in Canada. It was big headline news. So Canadians, if you ask Canadians if corporations are allowed to buy the government in Canada, they would tell you on a majority no, because the government made it so that they can't do that. And even I've talked to political candidates from the NDP and the Green Party, and they argue with me that there is no donations being allowed to be given by corporations to political parties in Canada since that law.
Well, it happens all the time, though.
No, this is how it happens. In the law that was written, they allow in the fine print. There's a section on loans. Political party members are allowed to take out loans with corporations, and those loans could be in the 3 different formats of loans, and one of the loan formats is non-repayable loans. So you can still get a loan that's a non-repayable loan, but it's not a donation. So like you said, put things in a different context, and it might not be applicable, right?
Okay.
So we're saying to the Canadians, we're not accepting loans anymore. Donations, but we're accepting loans. And the loans just have to be non-repayable. Well, I can't. I'm not even because it's a loan. I don't have to disclose it to you because it's a loan. So Canadians don't have to be disclosed to the loans that political parties take out because that's their personal private interests.
Mm-hmm.
So back before 2001, when they would get donations, it was all on the books. Who donated and how much.
And now it's all private, and so you have no idea. You can't follow any paper trails, and you don't know who's really funding the political parties, and you don't know who the allegiances are really owed to. So
exactly. And the people are further put into
slavery again.
Slavery.
Right. Okay, so I'm just trying to understand. So, okay, first of all, you're working on a court case. We started talking about that a few minutes ago. That you're actually now preemptively striking the government based on these incongruences in these laws. Okay?
I believe that the people at the top, the elitist chain, have committed the largest robbery in world history, and it's going on right now in Canadian banking system. And we're being robbed daily of hundreds of millions of dollars. Okay. Mm-hmm. that is forcing our people into further slavery, further debt slavery. Okay,
because we end up having to pay for those defaults.
The people at the top of the ladder, very smart individuals, have created laws in the Bank of Canada Act that governs the way banks establish money. Okay, and if we look, any Canadian, any reasonable person wouldn't realize the understanding of how money is created in Canada. And what they're doing right now to steal from us, and how they're further enslaving us in debt for the thousands of generations next that are coming in front of us to pay for that debt. We're being locked into a contract that we'll never escape unless we understand the law and understand the dynamics of the jurisdiction of Her Majesty the Queen over the people and how she's broken those laws and how we can repair this now. And this is the time that people need to start to read their law, understand their position, and start to argue back with legal, civil argument.
Okay, so are you of course, you made a few recommendations, and I just want to be clear with all the listeners here. Of course, you're not a lawyer, you're not a legal advisor. You're just an average Canadian like myself and everybody else listening to this call who is actually impassioned and say, I'm not standing for this any longer, and you're actually doing something about it. And by the way, you deserve a great big pat on the back for being one of those people who say something should be done, and darn it, I'm the one to do it. So thank you for doing everything that you're doing.
And believe me, a lot of people told me that if you stand up, they'll cut your head off. If you don't push too hard, don't poke the bear. Why are you poking the bear? And I say, you know what? I'm in a corner. They put me in a corner, and you know what? I started reading, and I started realizing that I'm not really in a corner. They're the ones in the corner. They're the ones that established the laws against themselves. They're the ones who've broken all the rules. So there's a part of law that holds people accountable for their actions. And so now it's up to the people to understand the law that governs them, and then to use that law to out those people that have been abusing their authority and abusing the law and abusing their knowledge of the people. And it's time for the people to step up their education level, their knowledge, and bring their knowledge to the table and say, you know what, we're not going to take this no more. We're not going to stand for this. We're people. We're understanding. We're reasonable. We're fair. We're appropriate. And no, we're not going to take this kind of shit anymore.
So what are some pragmatic steps that people can take? Now, of course, you've already mentioned a couple of them here, but perhaps you can reiterate them if applicable. What can we do?
to me, this is to do with not just marijuana. This has to do with Aboriginal rights, treaty laws, contracts that the government has over the people, taxes over the people, established jurisdiction, and pretty much our everyday way of life.
Yeah. As I've said many times before, and I think it's also been recorded with the other speakers too, marijuana is really just a drop in the bucket of social, political, environmental injustices that need to be addressed. Marijuana is just one issue. So everything that we're saying here, I'm sure that it's applicable, as you just pointed out, in other areas as well.
Exactly. And so what my initial goal was to find out the laws about marijuana and find out how, they were affecting me and how I could protect myself. And so that led to other areas of law that started becoming more relevant, and and I started understanding that, hey, what the heck is going on here? No reasonable person in their right mind would allow this to happen. How can this continue? So I asked some questions. I sent a letter off to the Attorney General for Canada on the email, and I said, Rob Nicholson, I said, dear Honorable Rob Nicholson, what does the Queen's Oath have to do with Canada? And did she break her oath to the people? And he wrote me back a letter, and he said, Mr. McElvenna, the Queen's Oath was only a symbolic oath.
Okay.
And so I looked in the dictionary. I said, well, what's symbolic oath mean? I look in the dictionary under legal oath and oath of a magistrate and oath over the people, and there's 50,000 different oaths that you could take. There's not one symbolic oath on there. Every one of those oaths is liable for punishment if you break them. You don't take an oath to break it. Mm-hmm. And there's no such thing as a symbolic oath. But then it reminds me to that age-old expression in the maxims of law, those who can be fooled will be fooled. And I think back, this is a trained advocate or lawyer at the top of his game, the best in Canada, working under Her Majesty the Queen, and he just told me a good fool. But it didn't fool me, because I looked in the dictionary. There is no such thing as symbolic oath. Okay? So then that got me to more thinking, what is going on here? There's a serious fraud being perpetrated onto the Canadian people. How do you let people know? I don't know. I'm going to university. I'm taking political sciences. I'm talking to students. I'm talking to teachers. I'm understanding the ways of the world. I'm reading articles and journal articles and every book I can get my hands on the political situation in the last 2,000 years. Mm-hmm. So it gives me a better understanding of where we sit today and how we can actually fight back, and if there's a possible way of fighting back. Most people have tucked their tails between their legs and said, there's no way, there's nothing we could do, I'm not going to do it, let somebody else do it, it doesn't concern me, I haven't been charged with nothing, I'm okay today, my water's still safe to drink for now. The complacency all around, and there's been serious warnings gone out to the people since the Second World War about this type of complacency, and that when we see something that's inherently wrong, that we should stand as people and speak out about it.
Yeah, well, that's essentially what I'm doing is because I'm not a lawyer and I don't really understand the law anywhere near as good as you do or something like that. What I'm doing because I'm trying the best that I can, because I got fed up. That's why I'm doing the summit, just for what it's worth. I got fed up with all these. And there's a lot of other issues outside of cannabis as well. But anyways, this is an issue that I can actually literally sink my teeth into and actually do something about. And I think we need more people in whatever way, whatever their talents are, whatever their abilities are, to stand up and say, this is enough. I'm fed up. And I'm not taking this anymore. Heck, wasn't there a movie about that, like an old TV personality who says, I'm fed up, and anyways, I can't remember. I'm sure somebody will remember the movie reference that I'm talking about. But anyhow, the point of the matter is this, is that we need more people to say something's wrong here, because I think enough people already recognize something's wrong here, and I hear what you're saying. I don't think the issue is is there something wrong? I think it's apparent to most people that there is something wrong. But what's lacking is, and Canadians perhaps are a little bit well known for this complacency. Like they raise the price of cigarettes in the States 10 cents. It's a major outrage. Whereas they raise the price $5 in Canada. Well, it's an outrage, but I guess I'll go to the store and pay an extra few bucks. We're just complacent in that respect. We need to actually start doing something about it. And not just Canadians, not just Americans, everywhere around the world. I think we need to actually stand up for what's right, and not take the injustices. And there's
I don't want to. I just don't want to stress this enough. I just don't want to stress this enough to Canadians that the most important thing to do is not to go and stand in the streets and express outrage at the situation. That's not the way to do it. That does nothing other than cause disruption to society as a whole. What we need to do is effectively target the regime by filing civil litigation for the wrongs that they're doing to Canadians.
And
Hello?
So you're one of the few people who are actually doing something preemptive in that sense, that you're actually not defensive, but you're actually on the offensive.
And that's what all Canadians that feel responsible for the outcome of our country should do, is to take their ideas, their complaints, put it down on paper in a civil forum, rely on the Civil Procedures Act, read it. I mean, I keep saying read it, read this, read that. It seems like a lot of reading, but I can't stress enough that we spend so much time watching Big Brother and watching just the news and watching and reading Time Magazine and all sorts of newspapers that really have no real merit. Whereas when you read law, you're reading freedom. You're reading how the laws govern you and how to protect yourself against the tyranny.
Mm-hmm. I love the way you just put that.
It's just not enough of us really understand how we're being abused. Not of us, we know we're being abused, we just don't know how.
Mm-hmm.
So once we read the law, and that's what I'm saying, the law is there for people to read it. Read the law. And they always use that expression against us. Ignorance of the law is no excuse. Well, now I'm using the same line back at them. Hey, you know what? Ignorance of the law is no excuse, especially by a sworn officer of the law. No?
You know what? That is an extremely valid point. Yes. How many times are the officers ignorant of their own laws that they're sworn to uphold? Right. That's
right. So I called the head of the drug department in Sudbury, and I went for a meeting, and he didn't want to talk to me. And so I actually bumped into him at the courthouse in a corner where he had to talk to me. And I said to him, look at the criminal code, like I just showed you guys earlier, and look at the Controlled Drugs and Substances Act. And then I showed him the acts. I showed him what HIT said because I had a copy of it on me. Just happened to have it on me. And I said, where's the inconsistency? And then I asked him about Section 52, and he goes, oh, well, Ryan, it's not in my mandate. And I said, ignorance of the law is no excuse. And he looked at me funny. And I said, I'll hold you to it in the court of law. You've been told, you've been warned, and I've just presented you the knowledge. You can't be ignorant to it now. Now what is he going to do? I'd say next, how is he going to arrest anybody? He's the head of the drug unit. If he does, he's ignorant to the law. And it's proof.
Now he's been informed of the law, so if you arrest anybody under those pretenses, technically, isn't he in violation of it? Well, he was in violation of it all along, but
now he's fully aware of it. So what we should be doing is writing up these letters to the police agencies and showing them where in law that they have to refer to, so that they're completely aware of it. And then ignorance of the law could be used against them because they've been made aware of it, and they weren't just unaware of it and made an accident or a mistake in law, because they're allowed to make a mistake in law. They're not allowed to make they're not allowed to be ignorant of the law.
Mm-hmm. Well, that's, I guess, technically a loophole right there. You can make a mistake in law, but not be. So your mistake could but you can disguise it as a mistake. So it's just
yeah, but you could protect against mistakes by providing affidavits or notices that they have to acknowledge. And once they acknowledge it, then they're aware of it. Once they're aware of it, there's no more mistaking it.
Okay.
So it's up to Canadians in all their little regions and all the towns and cities that they're from, the ones that are passionate about it, to write it up and make their police authorities aware so they can no longer be ignorant.
Well, I think it's not just Canadians. Actually, what you're saying is applicable to just about anybody, being aware of the laws and presenting it. Because like the States and most countries, I'm sure, has a lot of these types of incongruencies. If they just were to sit down and try to decipher all the laws and sort of think about it logically, I'm sure there's plenty of this stuff to be found, particularly now.
Yeah, particularly now at the advancement of knowledge and science in regards to human evolution. Today, our people are far more educated on a much larger scale, and we have the ability to really fix the world's problems. We do have the ability amongst nations, if we were to be a human that was to look for the future and take care of human evolution instead of looking to the profits of the few filthy corporations that have obviously tried to destroy us, and then rebuild us, and then destroy us, and then rebuild us, and then destroy us, and then rebuild us like a big game. Like the computer era, the internet is what I think is the freeing factor for humanity from this tyranny. I think that's where it is, because now we can access law, we can access the fundamental bases of the structures, the foundations, the fundamentals, and we could, as people, we know what's better for us. We could vote in a true voting fashion. I think that we could create a Senate back to the old days where Senate members were actually representative of their regions, that actually came to the Senate with the idea of voting in favor of ideas that would benefit their regions versus their corporations that own the whole party, and split the party into two groups and own the entire both groups. It's, to me, that's so undemocratic, and the people know it's undemocratic, and people just think there's nothing that we could do about it. I disagree, and I strongly disagree, and part of that is we have to learn the law that governs us, then we have to reestablish and in this reestablishing our jurisdiction and the laws that govern the nation, a group of great thinkers will be sitting there putting that together. That's what my belief. Because today's thinkers are a lot more advanced than the thinkers of the past, I believe.
Well, it would almost be an excellent point to just end this call on. However, there's one more topic I wanted to ask you about, although it was almost a perfect conclusion here. So let me just ask you this other question here, and then we'll wrap it up after that. Of course, you've worked with Paul Lewin before on other court cases in the past, and of course, I'm sure you're familiar with Myrna's case and everything that just happened just last month. Do you have any comments about what you perceive happened? Any incongruences that you might have already found there? Just because, of course, you're obviously sinking your teeth into this and really digesting this mentally. I'm curious to know what your perspectives on all that were as well. Okay. I believe that from my knowledge of Myrna himself, I know him. He is some people have. Okay, so how can I say this? He's not a good person, how can I be politically correct and not hurt everyone involved? I believe that there was an ulterior motive in the case itself, and the ulterior motive was to stall the government's proposed changes that they wanted to make. Before the whole Murdoch case came out, it was my speculation that the government had something up their sleeve where they were going to try to pull the entire program from under Canadians. Back in 2003, when they made the Hitzig decision,
to reestablish the laws through the courts and to temporarily rule the law to be of no force and effect, and then to immediately and after that reestablish the law through the court, which was illegal according to the Interpretation Act. I believe that. I'm sorry. I lost my complete train of thought there, Brian.
It's all right.
What did I just say just leading up to that?
You were talking about Myrna. You were trying to be politically correct there. You were talking about something about the Herzig back in 2003.
Yeah. Sorry. In the Hitzig case, the lawyers for Hitzig was Alan Young. Okay. And Alan Young was given a contract from the federal government to be the only pharmaceutical company in Canada to study cannabis. Okay. And that company was, at the time, called Cannabis Pharmaceuticals. And Cannabis Pharmaceuticals had the rights to a cannabis spray that was sprayed under the tongues of Canadians to get high on a cannabis product. They were also studying products on their website in regards to a $15 billion industry for patients with schizophrenia. So they're using a cannabis drug to medicate people with schizophrenia. Cannabis Pharmaceuticals was owned by 50% stakeholder by Alan Young. He was the majority stakeholder in the company. He was given that license in the time that he was working on the Hitzig case. There are some big problems there, and so I'm just gonna leave that with that, and let Canadians dwell on that idea that and do some research on their own about Alan Young and his pharmaceutical company back in 2003. That it was the only pharmaceutical company given the right to do cannabis research. Okay. Then we have this new case where the government's going to change they decided they're going to change the laws in Myrna because they struck it down, deemed it unconstitutional. But the government was then again given time to fix the law. During that time,
are you talking about the original 90 days, or are you talking about the practically 2 years?
They were given 90 days, and then they were given an additional 2 years. But the Ontario Court of Appeal now struck it down, so they don't have to fix nothing. But they're still in the process of fixing it.
Well, they're making it worse in a sense, actually.
So they're trying to fix it, or they're trying to make it worse. Either way, they're doing something to it right now, and this whole Murdoch case was just a sidewinder for people to look at to keep them distracted. That's what I'm saying, because the issues at hand there wasn't enough doctors, because we knew that in 2003, the Ontario Court of Appeal said that if they had 500 doctors, that would be enough. So any lawyer that was going to say that today there's 5,000 doctors and that's not enough, going against the Ontario Court of Appeal would lose. And everyone knows that. You would know that if you're a lawyer. So how did they argue that point? The point is, doctors don't have the right to opt out. They're not prescribing you medicine. They're only telling you that that they're aware that you're using cannabis, and that they've told you that there are possible side effects to the drug. They are not prescribing you because it's not a medicine that is prescribed or has a DIN number according to Health Canada. Okay.
Yeah, they don't prescribe other herbs either, right? So why should they prescribe marijuana, which is just another herb?
Yeah, all they require to do is to tell Health Canada that you're using marijuana and that they've told you that there are possible side effects to its use. And then they even make you sign a waiver that they're not responsible for signing the forms. So in that sense, they don't have the right to opt out of that process because they're not making any decisions to give you marijuana or not. They're just acknowledging that they've told you that there's possible side effects. That's it. And so trying to opt out of that There's no decision making that you have to make there. A disabled person only has their doctor to go and see. They don't have to wheelchair from doctor to doctor to doctor to doctor to find one that's agreeing with it. Out of the 100,000 doctors in Canada, that there's only 5,000 doctors signing is the proof that that's inefficient and it's unconstitutional and it's damaging to Canadian society to keep going on this way. So how do we find a remedy and a solution to that? I'm in the court arguing that we should be able to have compassion clubs that are set up across the country that have a Section 56 exemption from the law, so they're able to offer.
Section 56 from what? Where does 56 come from?
Section 56 comes from the Controlled Drugs and Substances Act, where the minister has the right to exempt people for medical and scientific purposes.
Okay, thank you for clarifying that. Carry on.
Okay, so I believe that compassion clubs across the country should have the right to be able to give out temporary exemptions to those who come in an established medical need by simply providing 2 pieces of government ID and providing their medical diagnosis that has been given them from a doctor.
Now, we've talked about that before the interview portion when we were just talking colloquially, because, of course, I've sort of given up temporarily getting my MMAR. I'm not going to get into that right now in this discussion, but something interesting that you said, which, of course, we actually read earlier on this interview directly from Hitzig. I keep on mispronouncing that. Hitzig. Sorry. So, of course, I think it was paragraph 4 that or perhaps it was one later. I can't remember which one it was off the top of my head, but demonstrating a medical need, right, was essentially all that you needed for the exemption. And so now, of course, you're talking about compassion clubs having the right under whatever 56 or something you just said to be able to issue some sort of a temporary permit based on the demonstrated medical need.
So you'd come into the club and you'd establish your medical need by telling the government or whoever at the club and providing your 2 pieces of ID to acknowledge who you are. So you have backup to say if you ever get harassed or intimidated by a police officer, you can say, no. I've established my medical need with the Northern Ontario Compassion Club. You can go to the database and check on that to see if I've actually breached any laws.
Right.
And now that's your proof that you've established your medical need.
So you've established the medical needs, and so technically speaking, you don't really need an MMAR according to the laws as it stands. Like, for example, I'm just sort of thinking myself, but I'm sure that what I'm talking for myself would probably be applicable for many, many, many others listening, many Canadians as well. So if you have all the documents that you were trying to get all your MMAR documents together, but you just can't get a doctor sign. Now, if you get a doctor, just some document from the doctor saying, yeah, you got this condition, not necessarily signing off on MMAR papers, but just having a doctor's paper stating that you have the condition, that's technically, according to what I understand from my interpretation from what you've said, that's all you really need. Am I understanding that correctly? Like, I realize that maybe the lawyers and the police might not necessarily agree, but isn't that essentially what the law is saying, that if you have some sort of proof from your doctor, that's all you really need?
That's all you really need, yeah. And so what I'm saying is that Canadians should do is take that and put that in an affidavit. Staple the diagnosis form that you got from your doctor in your medical records to your affidavit as evidence in and so
are you talking about submitting this to your doctor so that they have it on file, or are you talking about actually having a piece of the paper from your doctor, maybe even printing out the Controlled Substance Act and Herzig and stuff like that, and just keeping it around wherever you keep cannabis, so that if you ever get busted, it's like, hey, check out these paperwork here as well. Like police might not necessarily totally leave you alone from it, but I mean, at least you got something that's showing that, hey, you know what you're talking about.
Recording started.
I'm not sure what's going on here. I actually could potentially be me because I actually just switched call recording services because the other one they have a known problem which caused me to lose about 3 hours of interviews before yesterday. But anyhow, sorry about that. Do you remember where we were? And by the way, I gotta be ending this call very shortly because I actually have somewhere else to go.
Yeah, I remember exactly where we were, man. Okay. What I was saying is take a personal affidavit, right? And an affidavit could be a document. You can go on documents, legal documents, and look up what an affidavit and how to set it up. You know, I so and so do swear that all the contents are true, or swear or affirm, right? And then you could take that to a notary public, and they could stamp it as a legal document. And an easy way to go is to bring it into the local courthouse, and they have notary publics that offer services there for $13 to stamp an affidavit. So you take your affidavit and you take your next piece of paper is your doctor's diagnosis, and you label that Exhibit 1. And in your affidavit, you're going to state that you're bringing in Exhibit 1 is your doctor's diagnosis of your illness. And Exhibit 2, and in your affidavit, you're going to say that you use medical marijuana or marijuana for your illness because you're sick and you use marijuana for your health reasons. Mm-hmm. Now you're going to have to take that and get a judge's order that you've established your medical need, right? So there's a process where you can go into the courthouse and challenge the court to provide you with an order now that you've established medical need and offered this evidence into the court, into the legal body of the court, and they can't object your demands.
Well, this is actually really fascinating because, of course, I've spoken with a number of people regarding the MMAR, and, of course, it just seemed hopeless. It's like, what the hell do you do? Like, how can you protect yourself legally? This is like we say preemptive strike.
Preemptive strike. Before you get arrested with it and before you have to defend yourself because you say this is unconstitutional and this is wrong and that is wrong, go in, get your affidavit done, present your Exhibit 1, go into a court, and have your hearing and ask for your judge's order and tell them you've established your medical need and ask for your right to be able to use cannabis for your medicine. You've established medical need. Bring up bring up paragraph 170. And this is where the government has tried to trick us again. And I'll explain that to you right now quickly. In the Myrna decision that they took out of reserve when they deemed that it was actually constitutionally valid, through the argument that there wasn't enough doctors. Only through the argument that there wasn't enough doctors. They didn't say it was invalid for any other reason. They just said it's invalid. It is valid because there is enough doctors, which I said was going to happen in the first place. Find what established medical need is. They said in the Myrna decision that established medical need doesn't mean you're simply exempted from it. Okay?
Okay.
So they steer anyone that's reading this decision is going, oh, look, they did establish medical need, and they show here that established medical need means nothing.
Oh, okay.
Okay, except there's 3 judges in the Myrna decision at the Ontario Court of Appeal, and there's 3 judges at the Hitzig decision in 2003 at the Ontario Court of Appeal. 3 judges don't have the weight in law to overrule 3 other judges. So when there's a case of discrepancy between judges of one case to another case, they always go to the original case with the highest amount of judges, or the latter case with the higher amount of judges. In the case where there's 2 identical amounts of judges, they go to the first one for the real decision. So we still have to rely on Hitzig for the decision because the decision in Myrna does not override the decision in Hitzig. But it's a trick in law. They tried to trick people that are unaware and that can be fooled.
Okay. So the pragmatic takeaway lesson for a lot of Canadians who've been trying to get their MMARs, who got fed up with the system, I'm sure you can acknowledge it's not easy to get the MMAR. Okay, I'm sure you're quite well familiar with that as well. So they
Absolutely.
so they can go get an affidavit to establish their medical needs to be preemptive, so that if they get arrested, they have documents that validate that you tried, you did the best that you could, or whatever. I mean, technically speaking, what more can they expect from you?
I think that
they shot you down. You did some.
I think that once you establish your medical need in a court and you ask for a judge's order for established medical need, you're simply exempted from it. That'll be period. You'll walk out of the courtroom and you'll be exempted from it. You won't have a plant count. You won't have an MMAR. You'll have a judge's order exempting you from it because you've established your medical need with the legal body that governs Canada.
Wow, you know what? Okay, this was interesting from the very beginning, just talking about all these legal things, but I think we just stepped it up an interesting notch here for a lot of Canadians, because I think you've just given something that seems plausible. Now, I'm going to actually talk to somebody else just to see is there any holes or flaws in this logic, but this makes a lot of sense.
By all means, that's exactly what I want you to do. I want you to look into what I'm saying and then try to prove me wrong. Absolutely. That's why I don't profess to say that I know something unless I've done my research and I kind of understand it. And then I'll say, hey, look, what's going on here? And I'll ask a couple of friends that I have that are also lawyers. And if they scratch their noggins and can't give me an answer, I know there's something wrong and I have to look at it further. So nobody's given. I have a license, and I have a license for enough plants that I don't need to worry about going and getting I've had my renewals come to me every year. The government knows my position. I think they just agreed with me and just gave me the permit to shut me the fuck up. But I didn't. I just kept going. I kept going for other people because I didn't want a discrepancy, and everyone is deserving to be equal under the law. So if we're all deserving to be equal under the law, what gives me the right to have a license for 250 plants 4 times a year and somebody else can only have 25?
I think that's actually very admirable. To restate what you've just essentially said, you said that you got your license. That for a lot of people, they would just sit down and shut up at that point. Okay, most people do not make a stink if they got their license. In fact, most of the people that I've spoken to who do have their licenses, they're just complacent. They're happy. I got my license. The cops are not going to touch me. And oh well, I'm sorry for all the other folks out there, right? The people who are mostly active and vocal are the people who've tried but have been essentially unfairly, or whatever the reasons may be, they've been denied. And so they're the ones who are most vocal. But the people like you who've gotten their license, you could technically be just sitting on your butt being complacent because, hey, you got your license. They can't touch you anymore. But you're standing up for everybody else. And I think that's actually very admirable. Thank you very much for what you're doing. And for those of you who have your MMARs, I think it's extra important that you stand up, because a lot of people are too afraid to stand up, because, especially those who don't have their MMARs or their legal protection, because they're concerned about getting arrested. They're concerned about getting in jail and having their lives unnecessarily roughened up. But those who don't have those concerns, please stand up for everybody else. It's not just your own rights; it's everybody's rights. And we need to, until this is all legalized, I think we all need to stand up and band together, and together we're stronger. You know.
And absolutely, and so their system of justice, where they're not making money, is because you made an application without a lawyer. Okay, you made an application without a lawyer to get a remedy and an order, and you're taking up valuable court time where they're normally processing the cattle. Okay, and when you come in and you make an application with your affidavit to go in front of a court without a lawyer, who are you paying? You're not paying anyone. Okay, and now if we have hundreds of thousands of, if not millions of Canadians that draft up their own affidavit and walk into the courts across Canada, we've got a major problem on our hands that they have to fix right away. And don't tell me they're not going to legalize it just to get us all out of their hair.
You know what, that actually sounds like a really interesting movement. Imagine all the people who've been trying to get their MMARs, they just say, forget it, let's go about doing it this way, let's go to the courts with these affidavits. That would probably make us rock the boat at least.
That would be worse than having 100,000 people in the streets in downtown Toronto protesting for 3 days, because now we're actually hitting home in the pocketbooks of the people that are trying to force these unjust rules and laws onto us to profit from it. And now they're kind of screwed. They can't run their normal cattle through. They have to make orders every day talking about individual cases after case after case after case after case.
You know what? For what it's worth, I'm going to be sharing the content of our interview with the summit, and it's primarily, of course, for Canadians. But I think there's a lot of things that were said here that can also be extracting some interesting concepts for people of other nations as well. But I think we're leaving on this note here that there's a potentially interesting premise of organizing people to you know what, Ryan, like I don't have time right now before the summit to do this properly, but I think you understand where my brain's already going here. Maybe we should talk about this again at a later time, getting maybe someone who, an actual lawyer or something along those lines, just to see is there any holes in this logic, and perhaps helping people to organize in this way to take advantage of this legal situation. So, anyhow, I'm just thinking out loud. If you understand what I'm saying, I'm just thinking out loud. I haven't processed this out, but this is a really interesting idea, and I think that this might actually be helpful for a lot of Canadians. This concept, I'm actually quite excited about the possibilities and the implications of this, because it could actually help the individual, but it could also put together a fairly loud political message. Hey, Myrna did what he did, and bless him for trying. And of course, he's now going to the Supreme Court. We'll see what's going to happen with that. But at least we're not in a situation where we're just throwing up our hands and saying, "Well, what the hell can I do?" Now it comes back to a pragmatic thing that, hey, we have the power of doing something. And so, of course, to reiterate everything that you've also said in the call, is study the laws rather than watching TV and wasting time with trivial entertainment. And of course, entertainment is good from time to time, but not necessarily in the massive quantities that we indulge in it.
I tell you, once you start freeing yourself with law, it's the most entertaining thing that you'll ever encounter, because you'll start realizing, oh my God, I'm free. I'm free. Guess, look at this. I'm free. The law states that I'm free. It allows me to be free, because these people have held me in tyranny or into these classes of slavery or whatever you want to call it, subjects of a dominion, under dominion of another, in a contract that we've all agreed to, but we weren't given informed consent on. It's all the entire contract that we're involved in right now is a fraudulent contract or a quasi-contract under the law of contracts, because you can't be forced into doing something illegal.
Yeah.
And the thing that we're forced into doing illegal under contract, even if we've agreed to the contract to be subjects of Her Majesty the Queen, and even though we weren't the legal guardians who signed the application, when they signed the application, our parents, our legal guardians, who had the guardianship over us and the ability to sign our legal documents for us, when they did that for us, they were doing so in our interest. So it's like we did sign it. But even if we did sign it, and even if we are a party to the contract because we signed it, the contract itself forces us to pay taxes for indebtedness, which is a form of slavery, and that form of slavery is illegal under international law. And in thus that we're breaking an international law in order to uphold our contract, it forces the contract under the law of contracts to be a quasi-contract, an illegal contract, an unenforceable contract. And that's where the major root of the problem is. So we can all commit to the fraud and go in and file legal documents in the court and continue the way of life that's going on right now, like it's normal and it's okay, and we could all allow that to happen. That's the legal sense, that we allow it to all happen. But there is a way of breaking the chains and freeing yourself from the slavery. But that's another discussion.
Absolutely. Well, listen, Ryan, I think we're at a good point here to sort of end this. I think we gave a lot of really interesting food for thought. Again, I just want to remind everybody listening to this a couple of interesting, important points. That Ryan's not a lawyer. Or a legal counselor or anything along those lines. So Ryan is just sharing his opinions, and of course we're having a discussion that's not necessarily legally binding or anything like that. Any suggestions that we were given are, just ideas for you to consider pondering and doing your own research and seek your own legal counsel or whatever is appropriate for you. Just want to be very clear to protect Ryan and of course the Cannabis World Summit that this is not any legal advice. But I like what you also said, Ryan, about everything that you said, encouraging people to go do their own due diligence, do their own homework to verify the facts that you've stated are true, and find the flaws in your logic. Go ahead and find the flaws, and if you find the flaws, well, there you go. But also, perhaps there are no flaws, and that's also interesting as well for us to consider. But also leaving the thought that the pragmatic steps that you've shared throughout this call, and of course the last thing that we were just discussing is very interesting. So for what it's worth, Ryan, we're gonna wrap it up now. But for what it's worth, I don't think we're done talking in the sense that we might be revisiting this issue in the near future for the help of Canadians. And for those of you who are Canadians listening to this at the summit, I'm going to set up some kind of an email address that you can just subscribe to find out more when we explore this concept further. Perhaps we can send out an announcement just so that you can be kept informed of whatever we're continuing on down the road in the future. I'm not sure what we're going to do, if anything, but there's definitely some interesting possibilities. But before we end the call, Ryan, one last thing for you. Can you share your website? Where can people learn more about your seeds, your company, the Compassion Club that you have? Can you share your websites and talk about that for a little bit, how they can find out more about you as well?
Yeah, that's info, or they can email me at info@nocc.ca, or they could go on nocc.ca website.
All right, fantastic. So, folks, I encourage you to check out everything that Ryan's doing on these websites. I have to say, for what it's worth, I was impressed with you, and my levels of my levels of how impressed I am with you have continually escalated throughout the times that we've been speaking, before this interview and even throughout it. So, Ryan, thank you very much for taking the time to share all your wisdom with us here today, and I hope that something that you said will actually help a lot of people. So, thank you very much.
Hey, I thank you very much, too, and I just want to let you know that everything that you're doing for the industry is greatly appreciated by the industry, and I know that you don't have a license and that you feel that you're put up against the wall and you're trying to do your best. And like I said before, just keep focused on what's important to you, and it'll all come together.
Thank you for that encouragement. I appreciate that, and thank you for everything that you're doing, because you know what? We're all working together.
Yes. One love.
One love.
Peace.